order. I see we have quorum, and time is always the enemy of really interesting discussion and presentation. This is the 95th meeting of the Committee on Public Safety and National Security, and we are, of course, have the reference of dealing with C-59. We have two very well-known and experienced witnesses before us, and I'll just simply go in order of the way you're presented on the order paper with Security Intelligence Review Committee Pierre Blais, Chair, accompanied by Chantal Bowers, Acting Executive Director, and secondly, as an individual, Richard Fadden. So, Monsieur Blais, le commentaire est vous.
Okay. Excuse me. It's up to me to start?
Oui.
Yeah. Merci beaucoup. Good morning, everybody, and thank you for the opportunity to appear before you today to discuss the Bill C-59. I will focus my presentation in two main areas. The first part will lay out SERC's high-level response to the bill. In the second, I will offer a few suggestions for improvement to the language of the bill based on SERC's experience in this area. This is a positive time to be working in the area of review and accountability for intelligence in Canada. Not long ago, I was here to discuss the creation of the Committee of Parliamentarians in the context of the Bill C-22. I'm here again this time to discuss the government's proposal to create the National Security and Intelligence Review Agency, or the NCIRA, that I will use this abbreviation. I hate those NCIRA, NCCOP, CERC, CESAR, etc. I hate that, but we have to. I will go on with NCIRA. NCIRA, which will be responsible for reviewing intelligence and national security activities across government. Indeed, as included in the bill before you, NCIRA is to review any of CSIS or CSE, any activity carried out in any other department or agency that relates to national security or intelligence, and any other matter related to national security referred to it by the minister. This will bring dedicated national security review of the type that SERC has been doing for more than 30 years to a large number of other departments and agencies, including, in particular, CBSA and the RCMP. This will answer the gap that so many, including SERC, have commented on over the years. Lorsque le nouveau comité des parlementaires
On its own, the new Committee of Parliamentarians, or NCCOP, added itself to the proposals for the new NCIRA and the new Intelligence Commissioner. These three entities will represent a substantial change in the accountability system for intelligence in Canada once these three entities are added. And I will just take a minute to describe SERC's mandate and responsibilities to the committee. I would like to stress that SERC is an independent external review body that reports to Parliament on CSIS's activities.
Or responsibilities to carry out in-depth review of CSIS activities, to conduct investigations into complaints, and to certify the CSIS Director's annual report to the Minister of Public Safety and Emergency Preparedness. In a sense, SERC was created to provide assurance to Parliament, and by extension to Canadians, that CSIS investigates and reports on threats to national security in a manner that respects the law and the rights of Canadians. SERC has discharged its mandate faithfully over its history, and it has had an impact. This was demonstrated most recently by the Federal Court of Canada decision on October 2016 that confirmed SERC's long-standing practice of assessing the lawfulness of CSIS activities, including in how CSIS applies a strict necessity or the strictly necessary threshold to its collection and retention of information, which is one element that is all over the place now. Through its review work, SERC contributed to high-level discussions on the type of intelligence that CSIS can collect and retain, as we see in the dataset provision of Bill C-59. Cependant, la loi précise clairement que
But the legislation makes clear that NSIRA is an entirely new entity, to be created not from SERC or the Office of the CSE Commissioner, both of which will be dissolved when NSIRA is created, but from a desire to push the accountability agenda forward in Canada. SERC, along with its partners and counterparts in the review community, has long called for a change of this nature that will break down the silos that have hampered review for so long. When the decision was made in Canada more than 30 years ago to create SERC, it represented some of the best, most forward-thinking at the time on accountability for intelligence. But this is a new era with new challenges for accountability. Canada has an opportunity here to again fashion itself after the very best of thinking on accountability, taking into account the important experience of others. Now, with respect to the parliamentary element of accountability, this means designing a committee of parliamentarians. As you are already doubtless aware, I am pleased that the government did not stop at the creation of SECU, the parliamentary committee, and I'm pleased that the government has included equal attention to expert review carried out by SERC.
Similarly, adding substances to the review and oversight structures responsible for national security. In the UK, there is a new Investigatory Power Commissioner's Office. In New Zealand, there has been a doubling of the size of its Inspector General. In Australia, expanding the size and remits of its Inspector General for Intelligence is actively being discussed as we speak. Canada's deliberation on accountability are happening at a time when there has been a shift in thinking on accountability for intelligence agencies, translating into expectations of greater transparency among the public. To that end, one of the great strengths of the bill is the provision that allows for the agency to issue special reports when it decides that it is in the public interest to report on any matter related to its mandate. The new agency will issue these reports to the appropriate minister, who must then cause them to be tabled before each House of Parliament. This will allow the new agency to signal a significant issue to the minister and the public in a timely way. SERC is not currently able to do this, and it has been a limitation for SERC in its ability to present the results of its work in a timelier manner. In light of the government's recent statements regarding transparency, this is an important provision. At the same time, we note that there is no provision in the bill requiring CSIS to issue a public report to match the requirement of CSE in this regard. In the interest of transparency, SERC reviews this as an important gap that SERC puts to the committee to consider in its deliberation. Le projet de loi indique clairement que le César.
The proposed legislation makes clear that SERC and its experience will be central to what is coming. The transitional provisions clarify that at the coming into force of Part 1, SERC members, such as myself, are to be continued as NSIRA members for the remainder of the term for which they were appointed.
Okay. Well, I will run now.
Run.
Je vais. Qu'est-ce que signifient les changements proposés par le César?
What do these proposed changes mean for CERC in the immediate future? We will, of course, continue to review the activities of CSIS to ensure that these activities are compliant. You have them in written form, and I would encourage you to read the specific proposals for amendments, and if you have any questions, I'm happy to answer those. Now, of course, we're going to continue to review the activities of CSIS to ensure those activities are compliant with Canadian law and ministerial direction. And we will, as soon as we become NCIRA, we will rapidly implement the necessary mechanisms with the 17 or 18 new bodies that are under review.
Will be called to have a sort of MOUs with NCIRA to address the issue of how the review will be done. Obviously, it's a little bit early to address it. So we are, in closing, we are very happy with this new bill that will cover, I wouldn't say request, which is too strong, but that was discussed many times in the past, over the last few years. And I personally, as being involved for many years in national security, it will be very good to have whole organization, institution in Canadian government being able to share their informations together and having a better, I would say, better service for Canadians and when regarding national security. So I will stop on that and be
Thank you.
available for questions.
Thank you, Mr. Blais, and I think I'd be remiss if I didn't, on behalf of the committee, thank you for your service to Canada over an immense number of years. So I think you're well recognized for what you've done in the past. But similarly, Mr. Fadden, who's now retired but has also provided great service to Canada. 10 minutes, please.
Well, I'm going to take less than 10 minutes. I'd just like to make 5 points, if I could. First, if I were a member of the House, and I'm well aware that I'm not, I would have quite happily voted yay at second reading. I think this bill goes a long ways towards simultaneously dealing with security issues and concerns and charter and legal right concerns. But I do say dealing simultaneously. People talk about balancing the two. I don't think they need to be balanced. Each are so important they have to be dealt with as standalones and then adjusted as necessary. I think this is the case because the bill endeavors to respond to one central issue that it should address, and that's the level of threat faced by Canada and its allies. Otherwise, there's no reason to make changes. The only reason we have these agencies and their review capacity is because we're facing a variety of threats in the areas of terrorism, espionage, foreign interference, and cyber activities. In these areas, I think it's fair to say that our adversaries remain committed to pursuing their activities against Canada and our allies, here and elsewhere. It does not take a great deal of effort, I think, to see how a rebalancing the world's power relationships, adding a considerable instability to the world and offering opportunity to our adversaries, states and non-states alike. And I think we're only beginning to get a grip on cyber threats. I think that the additional authorities proposed in the bill, along with the new arrangements for review, reflect this not-so-brave new world. I only have one specific concern that I wanted to raise concerning the provisions in the bill, and they relate to the proposed Intelligence Commissioner. And my concern is not really about the security rights balance, if I can contradict myself, but rather it's a machinery of government or accountability issue. The bill proposes to give the Commissioner final say about a number of CSEC and CSIS activities, which in my view should be the responsibility of ministers of the Crown and not that of an appointed official. Giving a former judge, however eminent, responsibility for the legality of some activities is one thing and a good thing, but surely reasonableness should be the domain of ministers and of the officials to whom they are responsible, for whom they are responsible. In practical terms, if something goes wrong in the future, and whether this House or the Senate or a Royal Commission looks at this issue, it seems to me that the veto proposed to be given to an appointed official will make it too easy for the minister of the day to escape accountability. I say again that this is not a security issue, and I raise this issue because, as a concerned Canadian, I think we should have considerable respect for the fundamental principle of our unwritten Constitution, which is that ministers are accountable for delicate and sensitive things and not appointed officials. And under the current arrangements being proposed, you will have the agencies, Public Safety Department, the Department of Justice, the minister, and then an appointed official who may or may not know anything about national security determine in the final analysis whether in these variety of activities they can move forward. Having a former judge as commissioner determine legality, fair ball. It seems to me that while it's entirely lawful for Parliament to do this, it seems to me this is fundamentally changing one of the principles underlying our system of government, to give such a fundamental veto to an appointed official. So I'm going to stop there. I have a variety of views on some other parts of the bill, and I'd be happy to try and answer them should you have any questions. Thank you, Chairman.
Thank you, Mr. Fadden. And for the first questioners, Mr. Fragiscatos for 7 minutes. And I just encourage colleagues as they are towards the end of their time that they look. I don't wish to cut people off. So if they just look this way, and we can give them some indication of how much time is left in their minute. Mr. Fragiscatos, 7 minutes.
Not to worry, Chair. I've got the stopwatch
good.
going
Okay,
on the
good.
iPhone. So thank you to all of you for being here today. Mr. Fadden, most of my questions will go to you. And you're here as an individual today, and you have so much expertise in the realm of national security. I do want to ask you, first off, about CSE and the proposal to allow CSE to carry out offensive cyber capabilities. Last week, we heard from Ray Boisvert, who, as you well know, is the former assistant director of CSIS, who told us, quote, the best defense always begins with a good offense. When more than 6 countries are rumored to be developing active cyber capabilities, in my view, that means we must develop capabilities to respond, and in some cases that includes outside our borders. Could you, I take it that you're nodding, so I take it that you agree with this position. And in fact, are we, Mr. Boisvert, in his commentary to the committee last week, went even further and made the point that we're actually behind. That this should have, in fact, already have happened. Can you delve into this?
Yes, thank you, Chairman. I generally agree that the authorities that are being proposed for CSEC are a good thing. I would put it somewhat differently. Mr. Boisvert said that a good defense involves an offense. I would say that in the area of cyber, it's actually difficult to distinguish offense from defense. And that, for example, you can sit in Canada and build up firewalls. That's purely defensive, and we're doing that now. Is it actually offensive to think that when you know somebody's about to come in and do you damage, to try and do something about that? I would say that's still in the realm of defensive, although it's in a gray area. Offensive would mean actually going out with a plan and a strategy and try and do damage to somebody else. So at a minimum, at an absolute minimum, and I agree with the bill, you need to give CSEC the capacity to move outside of Canada and to take some positive steps. I'd also note that I agree with Mr. Boisvert. All of our close allies have been doing this for some time, and we've been subject to some under-the-radar criticism for not being able to do it. I would also note that because the authority exists doesn't mean that it will be used, blithely. But I think one of the great challenges of the day are cyber operations and cyber activities. And we need to have this, I think, to defend ourselves, using the word defense in the broadest sense.
With that in mind, what do you make of the criticism that groups such as the BC Civil Liberties Association have put forward, who have suggested that giving CSE an offensive capability would, quote-unquote, normalize state-sponsored hacking? What do you make of that kind of a critique?
Well, I don't agree with that. I think that under international law, states are restricted in what they can do to other states, but there's a big exemption to that. And one of those exemptions is self-defense, which is defined very, very broadly. And I think that most of what would be envisaged under the provisions that we're talking about would fall under the exemption in international law relating to self-defense. Technically speaking, it may be hacking, but it's hacking that's necessary, I would argue, for the national security.
You've also made the observation that our democracy, in effect, is under threat. You were quoted as saying, "I believe that it is likely a couple countries might have tried to influence our elections." Now, I'm thinking about CSE. I'm thinking about this offensive capability. Is it possible for CSE to act in ways to protect, for example, the integrity of elections in Canada?
I think that's rather more difficult. I was about to say that they could use existing powers, which enable them to try and protect federal institutions. The big difficulty in dealing with cyber, of course, is identifying where the problem is coming from. It may seem simple, but it's in fact very, very difficult. And in most cases, anybody trying to affect elections uses cutouts. I mean, you will have read as well as I have what is believed to have happened in respect of the last U.S. presidential election, and it's taken about a year before they have some reasonable assurance that it was the Russians. So I'm not sure I would use the offensive capability to protect our elections, but I would use that gray area of defensive moving into offensive if we can identify where it's coming from.
Final question for you. In a Toronto Star piece written shortly after your retirement, you were asked if Canadians needed to readjust their thinking about what makes a terrorist, and that and you replied by saying that most young recruits are those who, quote, feel that the Muslim world is under attack and that somehow Canada is contributing to that. With that in mind, would you suggest that the nature of radicalization is not religious in nature, that those who are going abroad and taking up arms are inspired by a political message in the same way that young recruits were inspired by the Spanish Civil War or something along those lines?
Broadly speaking, I would, although I think we have to acknowledge that it's often done under the cover of religion. I mean, a lot of people use the tenets of Islam to justify what they want to do. But I fundamentally believe that a large chunk of the Muslim world believe that they are under attack by the West. I had some research done once to find out when was the last time a Muslim country, the last time that a non-Muslim country was attacked by the West. Do you know what it is? Grenada. Every other significant military effort undertaken by the West, read often the United States, it's been against a Muslim or a quasi-Muslim country. So you can understand why I argue that they do feel under attack. And if you add that basic sort of gut-level reaction to everything that's on the internet, in the cyber world and whatnot, they do feel threatened. But having said that, religion is often used as a cover.
Thank you, Mr. Fragiscatos.
10
You
seconds,
still
so I
have
won't
30
take that.
seconds.
Oh, I do.
Oh, my goodness.
Okay.
Mr. Palouse, 7 minutes, s'il vous plaît.
Merci, Monsieur le Président.
Mr. Paulus, 7 minutes, please. Thank you, Mr. Chair. I'd like to thank our witnesses for being here. Mr. Fadden, let me start with you. You mentioned that you would have voted yay at second reading for C-59. However, our process was that there was no second reading. We brought it to committee at a request from the minister to all parliamentarians that we make important changes to C-59. Now, for you, specifically in part 4 maybe, but overall, for you, what would you suggest as a change to the bill? Thank you, Mr. Chair. As I said earlier, I would change the authorities given to the commissioner. I believe that that goes farther than what is necessary, and I think it affects the fundamental authority of the minister. And I'm not saying this because of Mr. Goodell specifically. I think it's an institutional issue. I would give CSEC the unambiguous responsibility to help provinces. The way the legislation is currently constructed, it limits the abilities of CSEC it limits CSEC's powers to federal bodies. But today, everything is linked. So, by limiting CSEC's abilities to play ball with the provinces and the private sector, as it does now, I think it sends an ambiguous message. And also, this is not necessarily a change to legislation because I think it's a good piece of legislation. But as someone who worked for CSIS and who's been a national security advisor, I am starting to get a little concerned about what we are asking of the institutions that are under the review power of Mr. Blais and his colleagues and the federal court. If the new committee of parliamentarians, the new CERC, the commissioner, the federal court, all of them, we're talking a group of bodies that will have quite a considerable effect on federal bodies. I recall when I was working with CSIS, almost all of the cases that go before the federal court are at least 150 pages long, even the smallest ones. It requires so many resources that ultimately I'm not convinced that the government gives these institutions enough resources to make their review duties efficient and effective. Thank you for that answer. Now, regarding part 4, on CSIS, in the bill, there's a little problem about the thresholds that are authorized. The new measures. Do you think C-59 will reduce CSIS's capacity to ultimately reduce threats? That's a difficult question. At the end of the day, I think only experience will show us whether or not that is the case. Generally, I would think not. I do think we're raising the basic level that's being required here to allow the agency to act, but ultimately, I believe there's enough flexibility here to allow us to proceed. And Mr. Fadden, you mentioned the various threats to Canada. What are the 3 biggest threats in your opinion? Which countries? That's hard to say. In the area of foreign interference and espionage, I would say China and Russia. You won't be surprised to hear that. I think those 2 countries are not comfortable with the current international equilibrium. They want to change it, and they are using tools that we would never consider using. Sorry, well, like what, Mr. Fadden? What kinds of tools? Well, for example, their cyber capacities, as I was saying with your colleague, they use them without any kinds of checks. In fact, in China, it is thought that 200,000 people are operating in the area of cyber espionage, some in the army, some in the government, some in the private sector. It shows a way of thinking about the issues that is different from ours. It's hard for me to name the 3rd country. I would prefer to say that it's terrorist groups. Now, thank you. Now, Mr. Blais. From what you said, we get the sense that there's a possible problem in the area of communications because there's so many agencies and sub-agencies that need to cooperate. The parliamentary committee, the review agencies, the information, the commissioner, the PM's advisory body, all of those groups have to participate in taking decisions and in decisions about national security. Are you not worried that with so many people involved, there may be leaks, intelligence leaks? Do you think it may be hard to protect that intelligence? Because we want so much to create bodies to protect the intelligence that ultimately it actually creates problems. Well, let me turn that around. The groups that have been added are parliamentarians. So I hope that you're not suggesting that it's the parliamentarians who will represent a danger. Because this new committee is going to have a more direct effect on the issues. Now, we have existed, CERC has existed for 30 years, and I think experience has shown us, and I don't want to brag, but we haven't been in the news for the wrong reasons. We have been able to keep confidential issues under wraps. I think confidentiality is still very important, and trust is also very important. what we need to ensure is there in all of the organizations that you mentioned is that people need to feel that they have trust in their superiors and that they are also responsible. Because, for example, at the Department of Finance, people aren't used to having people come to see if something has to do with national security. But I think that ultimately in any department, whether it be agriculture or transportation or whatever, anywhere in the federal government, I think that any of those people should be happy that when it comes to national security, they should be happy that independent bodies are checking whether the work is done properly and that mistakes aren't being made. Because, as you know, Canadians want to know more about what's happening, and they want to be certain that the law is being respected. And with this bill, I think we're meeting that objective. Thank you, Mr. Paulus. Now, Mr. Dubé. 5 minutes, please. Thank you very much, Mr. Chair. Thank you for being here, Mr. Blais, Ms. Bowers. Mr. Blais, I have a question about the presence or absence of various review mechanisms for the CBSA. Do you think we should have a committee or some sort of body that could carry out review activities for that agency, given that they play a more and more important role in national security? Is that a conclusion that you would draw? I think what you're raising was also raised by the minister, and please correct me if I'm wrong, but I think that Minister Goodell has clearly stated that he wishes to strike a body that will be able to review the CPSA's activities. Now, what we would consider are the activities of the agency that have to do with national security, and only that. I think there's a need for that because, as I mentioned, and as you know, when we investigate a matter of national security with CSIS or in the Secret Service, we weren't allowed to go to CBSA, but now we are. You could ask the minister himself. He has committed, I do believe, to create a body that will be responsible for reviewing the activities of CBSA in regard to issues that don't have to do with national security. Okay, but you discussed issues that do have to do with national security. How do you make that distinction? Because one could say that border security is ineluctably linked to national security. Well, hundreds of thousands of people get on a plane every day to go to all sorts of places. I don't have the numbers here, but it's remarkable. Not everyone who's leaving and coming to Canada represents an issue of national security. Yes, I agree. So in that context, is it a matter of following the breadcrumbs, to use the English expression? Is it that you see information that might have been shared with CSIS that causes you to examine what the CBSA has done? Is that the appropriate conclusion here? Well, it's hypothetical, but if someone were to arrive at the border who represented a danger because this individual had been identified by another country's agency as being a danger, this would be made known. A little light goes on somewhere. And then the CBSA would get in touch with the RCMP or the Secret Service so that checks could be made to see if they need to stop that individual at the border or take other measures. Either way, measures are taken. And there's also legislation that needs to be respected. We cannot just arrest anyone at any time. So our role is not to intervene at that point, but once the measures have been taken, our role is to determine whether legislation was respected. Mechanisms exist within departments to state whether some kind of national security issue has been raised. We can come to conclusions to see whether they were wrong or right to take those measures. But ultimately, it is the agency that needs to make the decision. Well, all the more reason then that we need a body to look at what the CBSA is doing. But there are some agencies which might be more likely to get into a situation that has to do with national security than others. As you so aptly said, with so many people arriving at the border every day, there are higher risks. Yes, indeed, and it is difficult to discern when it's important or not. Now, I don't have much time, so with your leave, I'd like to talk about the exemption for global affairs, which are exempted from being overseen by this new committee. Is that not problematic, given the role that... Answer: I don't think they're fully exempted with regard to information sharing. Well, I'm not that familiar with what's going on at global affairs, but I think that when there are issues that directly affect national security, they will nonetheless need to answer to the review bodies. As you know, for over 30 years, global affairs has been part of the system and has the closest of bonds, without going into any detail, with the Secret Service. Yes, I know there's consular affairs and so on and so forth, but do you think that what's proposed in the bill is enough to fill in the gap that exists here, that has been raised multiple times? Like in the Erard case? Well, without getting into specific cases, I think, given the way that the bill is worded, I think it covers all of the facets, both for global affairs and everyone else. I don't really see what the risk here is here. I mean, we'd have to see on a case-by-case basis, but the work that's done by global affairs with the other agencies, they're used to it. I'm personally not concerned about that. Having worked in this field for quite some time and being quite familiar with these files.
Left, and you have raised an interesting issue with respect to the exemption for global affairs, and maybe for the benefit of our analysts here, you could point to the section that you're relying on for that view.
That's what I'm trying to do, a 130-page bill. I can't quite get it quick enough in a minute, so you'll forgive me there, Chair. Thank you.
Leave it a bit open while I ask Ms. De Bruzen for 7 minutes, please.
Thank you to all of you for coming and talking with us today. One of the issues that I'm particularly interested in when I look at all of this is the question of oversight and accountability in the bill and how that's been arranged. And we've heard a number of people come to talk about, I know we said we're going to try and avoid acronyms, but in SERA, just to make it shorter, and how that's great because it breaks past all of the silos that we've had in the past, which has been a problem. But last week we had a witness come from the Canadian Bar Association, and he presented an interesting quandary about, is it too broad now? Is there a problem with the way that national security is defined for the NCIRA review that would be too broad? And I was wondering, given your own experience and given the transitional role that gets played, how do you see that? Do you see any concerns about the definition of national security for the NCIRA review?
Obviously, when you say before we had only 2 organizations or 3 that were review on national security, now we have 19 more or 19 altogether. It maybe it's too many. I don't think so. The question will be, NCIRA will be created. It will be new when the bill is adopted, and we will see by case. I would say that when we start as NCIRA, probably that we will not have a dozen of investigation in finance or transport, or we're going to go with where the real threat is, and this is where we look into the situation. I don't think the question was that we were complaining that we should have access to other departments and institutions that had national security matters, but we could not have access to it. So now we have. That doesn't mean that we will spend all of our time on that. I think that what we do usually, we make a plan when we start the year. We sit down with the organization, with CSIS, or with Mr. Fadden could mention. He knows that. It's not. We don't arrive, in the morning, knocking on the door, say, "Look, we want to see this and that." We don't do that. We cannot do that. We cannot intervene in their operation. So what we do, we prepare a plan. We say we'll look into this and this and this, and we report on it to the minister and to the parliament. This is what we do. It will not change. We will have more flexibility to extend and to look into area where we were not able to look into. It will be better for Canadians, I would say, because the accountability will be better.
So the breadth isn't a concern for you in the definition of national security in the statute for NCIRA?
Excuse me?
So it's not a concern for you, the way that it's been formed?
No, not really. It will be case by case. We'll see how it works.
All right. I was looking at your suggestions, and I believe that in your proposed amendments, you have one that I'm looking at the numbering. It's a little hard to work through. It's number 2 on page 2, and it refers to section 9, sub 1 and 10 of the NCIRA Act, and asking that they mirror the language of section 39, sub 1 and sub 2 of the CSIS Act regarding the access to information by adding to section 9, sub 1, quote, despite an other act of, I think it's any other act of Parliament, or any privilege under the law of evidence. Is that?
I'm sorry, you referred to number?
It's number 2 on page 2 under general. Is that?
Excuse me, I just want, because I want to make.
I'll just, as you look at that, the reason I'm raising that.
Section 39?
Yes.
It's a number that you're calling about the quorum?
No, it's on the number 2. It's just I'm looking. The numbering is funny, but it's the last proposal on that page, and it refers to basically granting access to information to privileged.
Yes. So what do you?
And so I just was drawing your attention to that because the Canadian Bar Association, when they came to speak with us yesterday, or last week, raised concerns about that, about waiver of privilege and perhaps providing a chilling effect on the type of legal opinions that are given, because there may be a broad range contained in any legal opinion as to what the options are, and then having that privilege possibly pierced could create a chilling effect on the legal opinions that are provided. Just have you thought about that as a possibility? What do you think about that concern?
Well, I think what we try to have is to have a kind of a level playing field. The level will be the same for everybody. It's important that people that are going through national security issues in the context as being a witness or being we had problems in the past. There were a couple of cases that went to the court regarding those points, and it was always a problem to deal with those matters. Who's entitled to some privilege or who's not, and we have to be careful with that. Canadians are not always happy with having some difference with that. The access to information, which is the objective of that, we have access to everything usually, but cabinet documents. This is where we are, and it should be this way.
I'm almost out of time, so I just wanted, on the flip side, you say in your experience, not having access to privileged materials has been a problem for you in your past studies?
I cannot remember any case where we were more I would say worried about the fact that we have no access to other departments than having really confidence document. It's not really a problem. I think it's accepted, and this is the law of the land. So we.
Maybe I could just add something as well. Is that
very
the
briefly,
issue,
please.
Very quickly. The issue is that what we've noticed with respect to the complaints before the organization. The access to information, specifically in that regard, is more narrow. And so up until now, we've had access to everything, including solicitor-client privilege documentation. And now we've noticed that in Bill C-59, that access to information is limited to specifically remove that solicitor-client privilege and information, for instance. And so that's the problem that we were highlighting.
Thank you, Ms. DeBruzen. Thank you, Ms. Bowers. Before I call on Mr. Motz for 5 minutes, Mr. Dubé, are you able to point to a specific section that you are relying? Okay.
Yes, thank you, Chair. I appreciate that indulgence. Juste rapidement, je parlais spécifiquement des...
Very quickly, I was specifically referring to the complaint mechanisms. If you look at the mandate, so in 8D, it's regarding investigating the complaints in sections 16.1 and 17.1 and 18.3, and then we also discuss citizenship or human rights. And when you look at these clauses, it mentions CSEC, CSIS, and it also mentions those who cannot get their security clearance from the government. So it would be impossible for anyone to make a complaint to consular affairs in a situation like that, Mr. Harrar.
Because you were asking a question that had in some ways puzzled the analysts here. We have very sharp analysts. There we are. Mr. Motz, 5 minutes.
Thank you, Mr. Chair, and thank you for being here, group panel. Mr. Fadden, this question is posed to you. Like with policing, the successes of CSIS and CSE are primarily unknown, and their failures very public. You previously mentioned your biggest fear at CSIS is having an attack occur in Canada, and then finding out after the fact that another part of our government knew of the threat and didn't share that information. So as someone who has dealt with these challenges for real, not just theoretically, what is this committee missing with respect to that aspect?
Thank you for the question, and this time I mean it, because it's the traditional answer. I didn't say it in my initial remarks, but I think one part of this quasi-omnibus bill, which I think is overly complex, is the one dealing with information sharing within the federal government. I would argue that there should be a positive obligation on any institution of the federal government to share with the listed number of institutions any information or concerns they might have about national security. The way the bill is drafted now, I mean, you need to have worked in the Department of Justice for 15 years to understand the standards and whether or not there's a positive obligation or not. I think this is better than it was the case when I was at CSIS, where there was no legal protection at all. But I don't think it makes clear to all and sundry that the overarching objective here is to share information relating to the national security to avoid a crisis. I mean, if you read that part of the bill, I don't think that comes through. There are so many conditions and thresholds and whatnot, I don't think it meets the standard. So if there was one part of the bill, I would argue you should strive to clarify and make very much clearer that would be the part. I don't think it meets, it would have made me more relaxed when I was at CSIS about the thing that you mentioned, but I would still worry that somebody in HRDC or Heritage Canada who might have tripped over information would still not feel comfortable calling up and saying, we have an issue.
Well, thank you for that. I appreciate that piece of information, and as a committee, I think that's something we should certainly need to focus on. One last question for you, sir. My time is limited. With this new bill, are we giving our security agencies the tools they need, or are we placing additional burdens on them with this piece of legislation?
That's a pretty big question. I think generally speaking, you're giving them the tools. You know, it's like a lot of other areas. Until they're actually out there in the field trying them out, it's hard to say. I worry a little, I mean, I haven't counted them, but the number of times that the words protection of privacy is mentioned in this bill, you know, is really quite astounding. I'm as much in favor of privacy as everybody else, But I sometimes wonder that we're placing so much emphasis on it that it's going to scare some people into dealing with information relating to national security. But generally speaking, I think they do have the tools. What does worry me a bit, and with great deference to Monsieur Blais and his colleagues, I think the review capacity, the review effectiveness, at least initially, is going to impose a considerable burden. Departments that have never had to deal with CERC all of a sudden are going to have to develop a practical definition. I think to call a spade a shovel, the definition of national security is going to be hard. I mean, I understand what Monsieur Blais was saying. It's not that clear when you're in heritage or agriculture or CFIA. What they're doing could possibly affect national security. There's one stream that's easy to follow, and that's if they use information provided by CSEC or CSE. But more broadly, I mean, if I can give you an example, a deputy minister once called me when I was at CSIS and said, my department, which has responsibility across the country for doing a variety of things relating to individuals, we think there's a pattern here which suggests that there's some foreign interference, and you ought to do something about it. 4 months later, our lawyers sort of concluded they weren't sure it was national security, and they were pretty sure they couldn't do it given the Privacy Act. Now, with great deference to lawyers, of which I was one earlier, I'm now no longer one, I think we need to find a way to simplify some of these concepts. And I know that once the bill is passed, if it's passed, there will be operational instructions. But my hope would be that in some respects, in some aspects of the bill, we could be a little bit less legal and a little bit clearer.
Thank you.
Well, let's hear it all for recovering lawyers. Mr. Spengeman.
Thank you very much, Mr. Chair. Mr. Fadden, a quick follow-up question on your comments and your recommendation regarding the Intelligence Commissioner. Is it your view that decisions of the Intelligence Commissioner would be subject to judicial review?
I don't have an answer to that, and I think if the answer is yes, I'm even more frightened by what his range of authorities could be. I think technically speaking, what I remember of the Federal Court Act, I think the short answer would be yes. And if that's the case, I think one of the things that the bill misses a little bit, although there are provisions for exigent circumstances, is that this Intelligence Commissioner in some circumstances is going to have to be alert and readily accessible, whereas he or she will be a part-time position. So I worry that there's a little bit loss in all of this about the world of national security, which requires rapid movement.
Thanks very much for that. A question to follow up on the comments of my colleague, Mr. Motz. We're in a time of tremendous transition. In fact, we've had rapid blurring of state, non-state boundaries and equal blurring of public and private domains with respect to data, certainly, and other issues. Have we put our eyes far enough onto the horizon in this bill to address potential unknown unknowns? I'm looking to issues like AI and quantum computing, that when you intersect them with security, especially cybersecurity, raise questions that we haven't even begun to wrap our heads around. Is this framework nimble enough and comprehensive enough, in your view, to address those issues which may come at us very quickly and unexpectedly out of corners that we haven't fully contemplated yet?
That's a very good question, I think. Mr. Chairman, I would argue most likely yes, because most of the definitions which attach to the World Wide Web, the international, digital infrastructure, are so broad that you could probably link in most aspects of AI and most aspects of the cloud. I think it would be better if there was some precision, to be honest. But, if I were still working and you passed the bill, I would argue that the two things you mentioned could be included in the definitions. But I would also worry that a bunch of people could also argue the opposite. But I do think the definitions now are pretty flexible. As long as you can link them in any way to the World Wide Web, I think you can include them.
That's very helpful. Thank you for that. Mr. Blais, you spoke about the importance of transparency and public trust, and in your written submissions, you've also addressed the work that we do very closely with our allies, especially our Five Eyes allies. How important will relationships with our allies be, not only in the work of actually doing the security work, but in reviewing security work? Do you anticipate that NCIRA is going to be in close contact with its counterparts in other jurisdictions?
Well, in fact, as you know, we are already in contact over decades with our five particular allies, the Five Eyes. As you maybe remember, we welcomed those partners earlier. In late September, they came over here. We have regular meeting with them to adapt our approach and to be more efficient. The question of obviously the organization that we're looking at are also having meetings and remain in touch with their allies as well on the Five Eyes and others, and it remains important. We already discussed those matters. What was going on here in Canada. We met with the British. We met with the Americans. All of them, and we go on with that. The way we develop our approach, obviously, particularly with almost 20 organization, is a little new in the area, and we will probably share our views on that. But for the time being, we're not yet there because the NCIRA will be in place probably later this year, at the best.
Thank you, Mr. Chair.
Thank you, Mr. Spengelman. And for the final 3 minutes, Mr. Motz.
Thank you, Mr. Chair. One question for each of you, different. Mr. Fadden first. We know that with the issues of cyber attacks and espionage and the interference that China's had with Canada, and with the proposed sale of ACON and the sensitive and national assets to China, is Canada really understanding and prepared to deal with the threat that China represents?
Well, you won't be surprised by my answer, which I think the answer is no. I mean, I don't think that we're oblivious to the threat, but I would argue that, and I make no distinction between governments here, but I would argue that we are schizophrenic on China. There are people who see real trade and economic advantages and see some security problems. Other people see security problems with some small economic and trade advantages. And I think because of this, it's been very difficult to have a national debate on China. But the good news is we're not the only one who have this problem. But I would argue we do not really understand in all of its complexity how much China is different from Canada and how they aggressively use all of the resources of the state, not just against Canada, but any number of other countries in pursuit of their objectives.
Thank you very much, Mr. Fadden. Mr. Blaise, one last question for you. In your role as CERC chair, would you say that there's a reason and justification for Canada to have a preventative arrest rules to stop threats before they occur?
The threat reduction
Yes.
measures?
Yes.
Oh, yes. As you know, we have the responsibility to review every year those threat reduction measures, and I would say it's so far a success, and it shows that it responds maybe an issue that was raised earlier in the discussion about the fact to be proactive, because I think it was new and it's successful. So far, so good. And we have the mandate to look into that, and we will go on with that in the future as well.
Thank you. One last question. As a former judge, you would have seen applications on recog orders and warrant applications for monitoring criminal and terrorist entities. So would you say that in this bill, we have everything we need and it's being done, that is being done in the bill to protect Canadians?
Well, I will be careful with my answer. What I would say, we have a charter. The charter people forget that from time to time, Section 1, that allows to go somehow against the charter or to excuse to go against the charter. What is the most important is that when the service or anybody has to act in any way, they should do that legally. If they're not allowed pursuant to the charter or to make some interception or whatever, they go to a judge, and the judge will look into everything to make sure that they could authorize that because there is a valid reasons. This is the basic of everything. We heard everything over the last few years, but we should remember that. When a judge is looking at this to make sure that the law is respected, we should be okay with that.
Thank you.
I strongly believe that.
Thank you, Mr. Motz. And I want to, on behalf of Mr. Fadden,
If I just make
given
a-
your seniority, I will certainly.
Well, thank you. It's very kind.
Yes.
I just wanted to say that, as I said, I think it's a good bill overall. I mean, I think a lot of people spent a lot of time working on this. But, you know, it is beginning to rival the Income Tax Act for complexity. There are subsections excluded, you know, they're exempted. If there's anything the committee can do to make it a bit more straightforward, it will probably facilitate the work of Mr. Blais and his colleagues. But truly, because of legitimate concerns about, you know, the rights, security, dealings with, some of the sections are almost incomprehensible. And I mean, I've spent most of my life working on, you know, federal legislation. This is not the simplest one. So I would, to the extent you can, I would urge any kind of simplification. Thank you for allowing me to say that.
Thank you, Mr. Fadden, and it appears that your recovery from your previous profession is well underway. So again, on behalf of the committee, I wanted to thank both of you for this very interesting discussion, which I regret to suspend, and we'll suspend for a minute or two while we re-empanel. So again, thank you. Let's bring this meeting back to order. We have our witnesses in place representing the Canadian Muslim Lawyers Association, Fazil Mirza, who is joining us from beautiful downtown Mississauga, entertainment capital of the nation. Not many people know that, but I'm sure Mr. Spengleman would be happy to spread the word.
Wholeheartedly.
Yes. And Ligne des Droits et Libertés, Denis Barrette, and Dominic Berchard.
Ligue des Droits et Libertés, Denis Barrette, and Dominique Péchard.
5 minutes early because we do have to deal with the subcommittee's report, and so I'll call it, as I say, 5 minutes early and ask that the room be cleared because it is a in-camera discussion. So with that, I'll call on Mr. Mirza for his 10-minute presentation, please. Thank you.
Thank you. Good afternoon, Mr. Chair, the members of the committee. On behalf of the Canadian Muslim Lawyers Association, thank you for the invitation to provide submissions about Bill C-59. I will start with our background. This year will be our 20th anniversary. We are based in Toronto with approximately 200 members across Canada that work in all areas of the legal field, including private practice and government. In terms of advocacy, we have consistently appeared at the Supreme Court of Canada dealing with balancing individual rights with state interests. We also assist the legal community and general public with legal education. Our underlying goal is to promote a justice system that is fair. Since 2001, we have had the privilege of providing testimony to parliamentary and Senate committees responsible for considering national security policy and law. In terms of my background, I am a criminal defense lawyer with 16 years experience litigating cases at all levels of court. I have acted as counsel in several national security cases. I am also an instructor in national security at the University of Toronto. Today, I'm speaking to you in my role as the chair of the Canadian Muslim Lawyers Association. In terms of my contribution, I wish to discuss two fundamental areas. First, the positive. We see the National Security Intelligence Review Agency as having great potential, especially if it's staffed properly. Second, I will raise our sources of concern. In particular, this bill does not address a key area of security. In particular, the legal threshold for searches of digital devices at the border. Further, there are real concerns about a lack of fairness and charter compliance regarding listed entities, which are noted at Part 7 of the Act. Dealing first with the National Security Intelligence Review Agency, which is at Part 1. For simplicity, I'll refer to it as CIRA. This institution has the potential to be a strong pillar of our democracy by providing robust review for national security agencies and their related partners. With more powers being granted to intelligence agencies to deal with evolving threats, this agency reflects the greater need for effective review and oversight. It certainly has a broad mandate, which we think is positive, including the review of activities of CSIS, the CSC, and RCMP, to investigate complaints against those services, to direct studies and prepare annual reports, and to report to the Minister of Public Safety. This strong mandate is a reflection of the expanding powers that are being provided to different agencies in order to effectively conduct national security operations. Clearly, there is more power to collect data, more power to share information, more power to conduct surveillance, greater protection of informants, more powers to engage in preventative measures. All of this is primarily done either ex parte or behind closed doors. As a result, a very strong review agency is critical to try to prevent mistakes before they happen. So how do we ensure that a robust review agency is able to address its role in a fair manner? This government has indicated that it is committed to representative institutions. Since CIRA will handle the review of security activities and investigate complaints, it is our submission to this committee for it to be effective. It is essential that it be composed of a diverse group of persons. It should not fall into the trappings of ineffective oversight bodies that are staffed by people that lack independence and impartiality. In 2006, in response to the Aurora tragedy, recommendations 19 and 20 specifically advised that the RCMP, CBSA, and CSIS improve composition and training of their staff to prevent mistakes based on racial and religious profiling. The same logic must apply to CIRA. Our concerns is that, as evidenced by the recent lawsuit brought by several CSIS employees alleging that some CSIS managers discriminate and stereotype against Muslims, that there is little accountability when this misconduct is reported, and as a result, there needs to be stronger training, better oversight, and diverse composition. In addition to CIRA's members, which are statutorily governed to be between no fewer than 3 persons and no more than 6 persons, there will obviously be a significant staff that's going to assist with investigations and providing assistance to those members. There will be an executive director that will assist with staffing the agency. It is our view that individuals in those qualified positions, high-level positions, must be aware of the community's perspective. The nature of the information to be drawn and the review of decisions would benefit from having a diversity of perspective. Our friends in law enforcement have confirmed that working with the Muslim community is key to identifying threats and solving major cases. There are numerous instances where that has happened, but there are also instances where things go wrong and members of the community are mistreated by those very same agencies. For CIRA to have legitimacy, it must recognize that perspective. It would be helpful if there was some statutory guidance with respect to the required qualifications and composition of the agency members and where people are going to be drawn in order to staff it. For instance, one from the judiciary, one person from academia, one person from the community with knowledge of these issues would be an important addition to the legislation. Moving ahead, my concern of what's missing from Bill C-59 is that there needs to be some statutory guidance when the CBSA may search digital devices at the border. We can debate and go over at length the fact that the bill has made progress with respect to balancing individual rights and state interests. But the reality on the ground is that all of that can be circumvented by searches of individuals' digital devices at the border, and the Customs Act needs to be revisited and reviewed. It's legislation from the 1980s that contemplated searches of people's luggage when digital devices were not the norm. The use of data collection is the future of national security, and the devices that people carry with them obviously are integral in terms of preserving a balance between individual interests and state interests and protecting our security. In today's era, most people travel. Returning Canadians can easily have their digital devices searched without restriction. A better legal threshold that reflects the nature of the technology needs to be established. Currently, it's the position of Customs and the government that there is no legal threshold to search individuals' cell phones, their laptops, etc., while returning at the border. Even with a reduced expectation of privacy in that context, it becomes critical that there at least be some legal threshold. Otherwise, the provisions in the Criminal Code or amendments to the Immigration Act or amendments to try and protect information sharing become easily circumvented when individuals are coming back through the border with no protections whatsoever. The last point I'll touch on very briefly with respect to Part 7 of the bill regarding listed entities. There is a fundamental omission in the Criminal Code legislation that needs to be addressed and fixed, and that is listed entities, as you're aware, are currently listed by process of an administrative regime where the Minister of Public Safety, based on a balance of probabilities, determines whether an entity should be listed or not. The difficulty is that the organizations which are then stripped and frozen in time in terms of their assets have no ability to hire a counsel in order to engage in submissions with the minister or to engage in the statutory judicial review. In fact, it's our understanding that this omission results in a constitutional violation where there's a Section 7 tied in with a Section 10 breach where these entities are not given an opportunity to hire and retain counsel in order to defend themselves. That constitutional frailty could be a significant problem for this legislation in the future. Thank you for the opportunity. That's my submissions at this time, subject to your questions.
Thank you, Mr. Mirza. And Monsieur Barrett et Monsieur Péchard, 10 minutes, s'il vous plaît, as
10 minutes, please. I will make my presentation on behalf of the League, and then either of us will be happy to answer questions. The Ligue des Droits et Libertés wishes to thank the members of the Standing Committee on Public Safety and National Security for inviting it to testify regarding Bill C-59. Since September 11, 2001, the LDL has made regular representations to defend the rights and freedoms established in international instruments in our charters, and to prevent their violation in the War on Terror. In the fall of 2016, during public consultations and the hearings, as well as the hearings of this committee, the LDL called for the complete withdrawal of Bill C-51, which we consider dangerous and unnecessary. The LDL also called for the introduction of an oversight mechanism for national security activities, similar to the recommendations of the Arar Commission. Bill C-59 addresses these issues only to a certain degree. We welcome the establishment of the National Security and Intelligence Review Agency. However, some conditions must be met before the agency can fulfill its mandate as watchdog. The size of the task awaiting the agency should not be underestimated. It cannot simply receive public complaints and reports from the organization it oversees. It should have the authority to initiate investigations itself. In addition, the agency must be specifically mandated to verify that organizations are carrying out their national security activities in compliance with the rights and freedoms established in the Constitution. This mandate must also include the review of ministerial directions to ensure compliance with the Charter of Rights and Freedoms. On this point, we would like to note that ministerial directions concerning information sharing must be amended to be consistent with the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. A significant number of organizations are involved in intelligence sharing. The Arar Commission counted 24 in 2005. The oversight mechanism will have a considerable task to do, and it will be an empty shell if it lacks the human and financial resources needed to do its job. We would also like to note that provisions in C-59 concerning the agency's public accountability do not go far enough, and an annual report is insufficient. The Minister, as well as the public and Parliament, should be informed when the agency discovers practices that are non-compliant with the Charter. The fact that the agency's recommendations are non-binding is also a concern. If the recommendations remain non-binding, the organizations concerned should be required at least to report publicly on the steps they have taken to implement the recommendations. Lastly, the agency should have the authority and resources to work with similar organizations from other countries. National security and intelligence organizations cooperate internationally, and the agencies that monitor them should be able to do likewise. And that brings me to the authority given to the CSE. The CSE can intercept anything in the international information infrastructure regardless of any federal or foreign law. For example, the CSE can intercept communications from U.S. citizens, and the National Security Agency can do the same regarding Canadian citizens for the purpose of sharing this information. Bill C-59 must prohibit Canadian agencies from receiving information on Canadians from other agencies that they would not have been able to obtain under Canadian law. While Bill C-59 provides better guidance for the more worrisome provisions of C-51, some fundamental problems remain. The repeal of judicial investigations is a positive move. However, an individual could still be placed in preventive detention for 7 days without being charged, even though C-59 raises the threshold for this detention. We urge that this measure and any previous provisions concerning this measure be removed. Now, with regard to the powers given to CSIS by C51 and amended by C59, that is a major concern. It is unacceptable for CSIS to be authorized to compile data sets on Canadians. There are no limits on the data that CSIS can compile, as long as the data is considered public. And that's a very broad term. Judges may approve the compilation of other data sets based on a very weak threshold. The only requirement is that the data be likely to assist CSIS. These provisions make it legal for CSIS to continue to spy and compile dossiers on protest groups, environmental protection groups, indigenous groups, and any other organization that is simply exercising its democratic rights. CSIS can count on the support of CSEC, which is also authorized to collect, use, analyze, retain, and disclose publicly available information, and whose mandate includes providing technical and operational assistance to agencies responsible for law enforcement and security, such as CSIS. These datasets also pave the way for big data and data mining, which in turn leads to the compilation of lists of individuals based on their risk profile. We are opposed to this approach to security, which places thousands of innocent people on suspect lists and targets Muslims disproportionately. Bill C-59 allows CSIS to continue to address threats through active measures such as disruption. These measures can limit a right or freedom guaranteed under the Canadian Charter of Rights and Freedoms if so authorized by a judge. It is important to note that this judicial authorization is granted in secret and ex parte, so that the individuals whose rights are being attacked cannot appear before the judge to plead their innocence, quote-unquote innocent, or argues that the measures are unreasonable. They may also be unaware that CSIS is behind their problems, which would make it impossible for them to lodge a complaint after the fact. These powers recall the abuses uncovered by the MacDonald Commission in order to counter the separatist threat. So we are therefore strongly opposed to granting these powers to CSIS. We are also extremely disappointed to see that the Secure Air Travel Act preserves the no-fly list. People are not told why their names have been placed on the list, and if they appeal, the judge hears the case ex parte based on evidence that the individuals cannot challenge, and that may even be inadmissible in a court of law. The Human Rights Commission condemned this lack of effective recourse in its 2015 comments to Canada. It has never been proven that the list increases the safety of air travel, which makes the situation even more unacceptable. England, France, and other countries that are targeted by terrorists far more than Canada have no such lists, and yet the safety of their aircraft is not affected. We ask that the Secure Air Travel Act be repealed and any no-fly list be destroyed. Now, with regard to the Security of Canada Information Sharing Act, the Act allows 17 government agencies to share among themselves information that is in the possession of the Canadian government. While C-59 amends the preamble to the Act to state that information must be disclosed in a manner that respects privacy, the Act's provisions contradict this very principle. As the Privacy Commissioner told the committee on December 7, 2017, the Act does not comply with privacy requirements. The threshold for disclosing and receiving information must be strict necessity. We also support the Commissioner's request regarding the role he should play in enforcing this Act. Now, in conclusion, we would like to submit the following list of recommendations regarding Bill C-59. While some of the bill's provisions are beneficial, a number of other provisions should be amended or deleted in order to truly protect Canadians' rights and freedoms. Our recommendations are that the National Security and Intelligence Review Agency have the material, human, and financial resources needed to carry out its mandate, that the National Security and Intelligence Review Agency be mandated to ensure that national security organizations carry out their activities in a manner consistent with the rights and freedoms established in our Constitution, that the agency report publicly on any rights violations that it has found and on its recommendations, that the organizations concerned be required to report publicly on the way in which they have carried out the agency's recommendations, that in the course of its mandate, the agency be authorized to share information with equivalent agencies in other countries, that Canadian organizations not be allowed to obtain information on Canadians from other international organizations that they would not have been able to obtain themselves under Canadian law. That Bill C-59 repeals Section 83(3)(4) of the Criminal Code, authorizing individuals to be placed in preventive detention for 7 days without being charged. That strict necessity be the threshold for disclosing and receiving information under the Security of Canada Information Sharing Act. That the Office of the Privacy Commissioner of Canada be mandated to ensure that Canadians' privacy is respected under the Security of Canada Information Sharing Act. That CSIS be stripped of the power to address threats through active measures such as disruption. And finally, that the Secure Air Travel Act be repealed and any no-fly list be destroyed. Thank you very much.
Mr. Perchaud, and congratulations, you finished at 10 minutes exactly. Monsieur Robillard, 7 minutes, s'il vous plaît. Bienvenue au comité.
Merci.
Welcome to the committee. 7 minutes, please. Thank you very much. Mr. Péchard, at your last appearance, you also criticized the offense that has to do with fomenting the terrorist acts. There are various people who said that that offense would be anti-constitutional. This offense that consists in advocating or promoting terror in general, because it ultimately will disrupt freedom of expression in an unreasonable manner. Now, Article 83.221 refers to counseling another person to commit a terrorism offense. What do you think of this new wording? Well, we believe that this is an improvement, and it does not threaten freedom of expression to the same extent. However, to counsel another person to commit a terrorism offense, to commit a criminal offense, rather, is in itself a criminal offense. So, with that in mind, I don't see why we couldn't have simply repealed this provision. Because in any case, someone who counsels someone else to commit any criminal offense, including a terrorist offense, can already be considered guilty under the criminal code. Mr. Barrett, before appearing, you stated that in the Air India affair, the use of investigative measures was a fiasco, and that we should consider the necessity of the authority given to police officers. Now, under Bill C-59, in sections 145 and 147, we are eliminating the investigative measures that have not been used since the Air India affair. Could you tell us more about the fiasco that resulted after the use of these measures? Well, firstly, that's something that we welcome in C-59, that we are ending the use of these measures. And it was a fiasco, because what was said about this is that the only time that this provision was used, it was completely useless in the Air India case. It did not lead to the results expected by the police forces, and additionally, the accused was not, it was inadvertently, ultimately, it was not intended that the media should know that there was a hearing. You can ultimately see in the ruling, you can see everything that happened. It was not a great moment for Canadian jurisprudence, given additionally that it was a tragedy.
Time with MP Damok.
Thank you very much. Thanks to all the witnesses for being here. My first question is actually for both of you. Currently within C-59, there's no necessity threshold to retain personal information that is disclosed under SCISA. I'm just wondering if you think that an amendment to that effect of introducing a necessity threshold for the retention of personal information as well as a destruction obligation that does not meet the necessity threshold would be helpful to increase transparency and also to protect individuals' privacy. So maybe I'll first turn to the BC or the Muslim Lawyers Association.
Yes, thank you for the question. My understanding from the CSE director is that with respect to the collection and retention of data is that if the data is innocuous, that they are obliged by law to terminate it or destroy it. And only if it has an intelligence value are they permitted to then take the next steps with respect to considering whether to share it in the retention period of it. A necessity component would obviously be helpful in terms of delineating and making it more clear to the agencies the circumstances under which the data should be retained. I think that when we use words like necessity in the national security context, they're not viewed the same way as they are, for instance, in criminal statutes or otherwise. In fact, it's easier for the government to be able to satisfy that threshold in the national security context. So for those who may be critics of using a necessity type threshold, as you proposed, it's probably not going to be as onerous as it would be in other contexts. And so if it provides some degree of protection, then it makes sense to ensure that that type of guidance is provided to the agencies. I mean, one of the big dangers that we have as data collection becomes normalized in the current society and where we have all of these different sources of data available to intelligence agencies is exactly what's going to happen with the information, how it's going to be stored, and how long it's going to be retained. And so if you start on January 1st with a type of information that may be of some intelligence value, but later it's determined to have no value in the sense that the person is no longer a suspect, then that is the type of criteria I'd like to see where that information is destroyed. So in other words, just because at one point in time it seemed to have had some value doesn't mean that it somehow permits the infinite retention of that material.
So I only have a minute left, and I want to let the other witnesses. Do you have anything that you'd like to add?
Well, I share what the representative from the Muslim Association, Lawyers Association, has just said. I think a necessity requirement would be a definite improvement, and it would provide some standard to evaluate data retention. And because, of course, as mentioned, one of the threats we see in what's proposed is the fact that there would be data banks that could be built upon on Canadians.
I only have 10 seconds left. Is necessity the right word? I'm out of time.
Yes, I'm not a lawyer, but he's a lawyer. He thinks so.
Okay. Well, thank you for that. You're going to have to work it in at some other point. Who's first? Mr. Motz first. 7 minutes, please.
Thank you, Chair. Mr. Mirza, let me begin with you and your group. Thank you, both groups, for being here today. Appreciated by the committee. Mr. Mirza, what would you add to C-59 that you think is absolutely critical for public safety, balancing the need for privacy and rights?
Thank you, Mr. Motz. As I indicated in my initial submission, I think that the government, the opposition, should start to take a look at reviewing the Customs Act. It is a piece of legislation that is significantly outdated with respect to the ability to review digital technology. And when you speak about balancing individual rights versus state interests, obviously we support measures that are going to protect Canada and provide us with a sense of greater security and safety. But that being said, all of us carry digital devices, including everybody that's in this committee. We all carry laptops. They contain the most sensitive information that you can imagine. And the Supreme Court has said that there can be no greater invasion of the privacy than going through someone's digital device and laptop. And so customs officers, CBSA officers who are there trying to protect the border need some guidance with respect to how far they can go in terms of searching someone's digital device. Right now, they have no guidance because if you look at the legislation, particularly under Section 99, it speaks to essentially an era where we would have our luggage searched. Okay, and second, where we would have our personal effects searched, and third, where we would have our body searched. Okay, as the suspicion level rises. But digital devices are a whole different world, and we need the legislation to start catching up with the technology. And if you don't do that, I guarantee you there's going to be constitutional challenges to that legislation when individuals who are coming back are having their devices searched. And I suspect it's my view that the Supreme Court is going to say that there has to be a legal threshold there. And in the absence of that, you have a constitutional violation. So what's the appropriate threshold? You could start with as low as a reasonable suspicion, which is not very hard for a CBSA officer to satisfy. They essentially just have to articulate some grounds as to why they think the person is suspicious. Okay, a better ground would be a reasonable grounds threshold, and even that's not very hard to satisfy. And I know, sir, from your policing background, that you would be familiar with both of those thresholds.
Thank you very much for your comments. I just have one last question before I pass it over to my colleague, Mr. Paul Hoos, to continue on with my time. And I ask it of the group here that are here in person. We've been hearing that free elections in Canada and in other democratic countries are under threat from foreign influences. Now, this is a concern to many that others can undermine our own democratic institutions. Now, the letter that you sent us was co-signed by Lead Now, who it has been reported that they've received tens of millions of dollars in foreign funding to influence the 2015 Canadian election. Now, do you feel that them as a co-signatory undermines the message that you have here for us today?
Pardon me, who received tens of millions of dollars?
Leads Now.
Leads Now.
Yep, Lead Now.
And what does Lead Now have to do with?
They co-signed the letter that you sent to the committee.
Oh. The letter, to what effect? I'm sorry, I'm a bit misled by the...
Oh, I'm sure you are.
Yeah.
The letter that you sent us, the information that you sent to the committee, had 29 signatories on it. Yes? Okay.
I'm sorry, I don't...
I'll talk offline to you afterwards about that then.
Okay. I'm sorry.
It's this letter here that you sent, and it has all the organizations that support the comment that you made, or the comments that you're making, and it was sent not to the committee. It was sent to Minister Goodale, Minister Wilson-Ribillard, and Minister Hussein in September of 2017. That's the letter I'm referring to.
Maybe in order to be fair to the witnesses, we'll suspend that question. I'll come back to you, but we'll have to take it off some time.
No, thank you.
So maybe you could, maybe the clerk could circulate the letter to the committee, because obviously the witnesses are confused by your letter. And meanwhile, we'll go with Mr. Paulus.
Is the letter in French and English?
Merci, Monsieur le Président. Merci, messieurs, d'être avec nous aujourd'hui.
Thank you very much for being here. Thank you, Chair. Now, when you presented your brief, you mentioned that you've been working since September 11th, 2001, and of course things have changed since then. And you put the term war on terror between quotes. So, why is that? Is it because you don't think we should fear terrorism? It does not in any way imply such a thing. We do recognize that terrorism exists and that it's a problem. But we don't think that it's a war in the sense in which the word war is usually used in international law. We feel that terrorism is ultimately a criminal activity, similarly to, say, international drug trafficking networks or something like that. We feel that the term war has been used to justify, well, dramatizing the situation in the eyes of the public and to stir up fear and to enable provisions to be adopted which, in our opinion, do not improve our security but actually instead attack our rights and freedoms. That's why we used quotes. So fundamentally, do you believe that there's some type of machinations here to scare people and that potential terrorist actions don't exist? We have seen that actions have been taken that have prevented terrorist action in Canada. So do you think that's something that's been made up? No, I don't think terrorism is something that's been invented. But if you look at the tragic events, for example, when 2 Canadian soldiers were assassinated or murdered in Canada in October 2014 in 2 separate events, or if you look at the descriptions that were made of that event, you would have thought that Canada as a country was being attacked. But that was an exaggerated way of putting the situation. It was a way to promote C-51. Canadians agreed with that bill right after the attacks, and then Canadians became less and less favorable to the bill as 2015 went by, because they increasingly realized that what was in it was not necessarily something they agreed with.
Dubé, 7 minutes, please.
Oui, merci, merci, Monsieur le Président.
Thank you, Chair, and I'd like to thank all of our witnesses. Now, Mr. Barrett, with regard to incidentally acquired information, it's something that comes up with regard to CSIS's and CSEC's collection, or information gathering, rather. Do you have anything to say about that? About the need for justifying the retention of this information? Because I get the sense that during an inquiry, it would be relatively easy to justify the acquisition of this information. Is that a concern that you share? Could you elaborate more on that? Well, indeed, this accessory information, we know that the agencies collect so much information. We saw that with Edward Snowden, and we saw that with the retention of this information that is collected incidentally is a real problem, but ultimately, this information that's collected about people who are not ultimately the target of an inquiry and are not suspects, this information that was gathered should be destroyed. When the information was inadvertently gathered, it should be destroyed as quickly as possible. And with regard to the new commissioner position, in part 3, there's an article, or there's a section where they talk about the fact that the minister could renew the authorizations for the duties of the CSC without getting the commissioner's approbation. Is that a problem? We would want the commissioner to be able to look at that, because the conditions that prevailed at the time of the first authority, the granting of the first authority, might not apply anymore. Nonetheless, I would say that we are not convinced that the role of the commissioner, well, the commissioner is almost giving the impression that a quasi-legal study of the minister's decisions will be made as a kind of check or balance. However, we have to ensure that the information that the commissioner gets to decide whether he or she approves the authorization or not, well, it all depends on what the intelligence services provide. The minister gives the authorization. If the minister is given the authorization, there's a lot of pressure on the commissioner to approve it. In addition, no one wants to be responsible for having denied some authorizations and having that lead to a later security breach. No one wants to be responsible for that. And so it's hard for the commissioner to oppose themselves to this file presented by the security services. So our concern is that the commissioner will ultimately be a little bit like the FISA court in the States, which is known to ultimately be a rubber stamp. So we're not against the commissioner's role in this, but for it to be an adequate protection against rights violations, well, we don't know if that's going to be the case yet. Now, there's 2 questions that I would take away from your answer. Firstly, the position is described as being essentially a part-time position. Given all the complexity and the workload that you've just described, is that appropriate, or should it be a full-time position? After all, if it's a retired judge, it might be quite possible for this person to occupy that position full time. Well, we haven't specifically made a recommendation about that, but the fact that it's a part-time position does surprise us, given the importance of these duties. The necessity for the commissioner to study all of the various proposals and authorizations in a thorough manner. We believe it's reasonable to have it be full-time. And my last question, which may be difficult to answer in the short amount of time that is left to us, you just said that it might be difficult for the commissioner. You mentioned the automatic authorizations. You said that the commissioner might have a hard time opposing the minister's will, and that it might end up becoming just a rubber stamp. However, what could be positive, there could be positive effects, but we don't know if that will be the case. So if that's not the ideal solution, what are alternative ideas that we could explore in future to ensure that we do have an effective system of checks and balances, which you don't have right now? Well, what we hope is that the review agency will be able to carry out a review that will preserve Canadians' rights while the intelligence agencies can also freely carry out their work. So we believe that the agency needs to have the necessary resources, just as Mr. Mirza said. But we also think that the agency needs to be a little bit like the privacy commissioner when it comes to protecting privacy. We need to ensure that it's a clearly arm's length in organization. We need them to also possess a high level of expertise, and we need the commissioner's mandate to be accountable to the public. We think what's missing in C-59 is that we get the impression that this agency is ultimately more going to be accountable to the government rather than to the Canadian public. That's why we think that C-59 could be improved to make the commissioner more of a watchdog that is accountable to Canadians rather than the government when it comes to seeing whether the intelligence agencies are respecting rights. Thank you very much, Mr. Dubé. Mr. Bruson.
Mr. Mirza from the Canadian Muslim Lawyers Association. And I also participate in a committee, the Heritage Committee, which recently tabled a study on systemic racism and religious discrimination. And I believe some of your colleagues appeared before that committee talking about some issues that we were looking at there. And I see a bit of an intersection when I hear some of the issues that you're raising here. So I was wondering if perhaps you could help. One of the recommendations from that study was that much like we have a gender-based analysis that we apply as a lens to legislation, that we should be applying an equity lens when approaching legislation. And given some of the issues that you've raised, I'm wondering if you have any thoughts about how we might properly apply such a lens when we're taking into account this national security legislation, to take into account some of the issues that may impact the Muslim community, as you've pointed out in a few instances, in a differential way.
Sure, thank you for the question. Yes, there is a tie-in. I mean, let me try to take it back to first principles. If you're looking at legislation that has a disproportionate impact on the treatment of women, for instance, I think everybody would agree that it's appropriate to have the women, female perspective with respect to that, and have some diversity of female opinion on a committee that reviews that. So if you were looking at an issue that disproportionately impacts the Indigenous community, it would only make sense that you try your best to have the Indigenous perspective accounted for. We ask for no less with respect to national security. It's straightforward and well recognized that in today's era, for reasons that were provided to you in the previous panel by the former director of CSIS and the intelligence agencies, is that there is still a significant focus on radicalization within the Muslim community. At the same time, there is a significant degree of cooperation. And what gets lost in the politicization of these issues is that it's actually the Muslim community that works very closely with CSIS, the RCMP, in helping to identify threat security and providing input with respect to what's appropriate to look at and what's not. And then they're also on the receiving end of mistreatment, unfortunately, because that's the nature of what happens when you have large organizations trying to review the conduct of an entire community. There's inevitably going to be some transgressions. So what we'd like to see is to have the National Security and Intelligence Review Agency have that perspective included. So we're not looking for affirmative action here and saying that you have to have, for instance, X amount of Muslim people staffed in that organization. What you need to have is a diversity of perspective, people who understand those issues, people who have the qualifications to do that. Philosophical diversity is important, number one. Number two, having some sense of what it's like on the ground for people in that community is important. And yes, you are likely to get people who have a better understanding of that if they're from the community. And there are today many qualified people that can be chosen from academia, from the legal field, that could be of significant assistance in fulfilling that function. And so that's why I think it's important that this committee, take that under advisement and perhaps even consider putting into some statutory language how that review agency should be composed. There's also another significant omission, which is somewhat startling, is that there's currently nobody that serves on the special advocate roster that has that degree of expertise. Now, don't get me wrong, there are very distinguished lawyers on that roster, lawyers that I know and respect. But if you're talking about going into the secret hearings and providing a perspective about what type of expert evidence should be heard or what other type of information should be heard for the reviewing judge, you should have someone with familiarity of those types of issues.
All right. Thank you. That was very helpful. Now, just wanted to make sure that I have it clear, because I'm trying to look for some concrete things that I can apply when we're looking at this legislation, taking into account, for example, NCIRA composition, and there have been all sorts of suggestions that have been made by others in recommendations as to how that should look, that we should ensure that there's a proper diversity. And when you said philosophical diversity, but that should be part of the lens that's approached. If I was going to give any other concrete solution that I might try to put in here, do you have something else that you would like to see us do specifically?
Yes, I mean, I'd like to see legislated that, it has a minimum of 3, we'll call it the highest level officials, and up to 6, and they're renewable for 5-year terms. And I'd like to see some understanding as to how that's going to be composed, so it doesn't fall into the same scenarios that you see other ineffective oversight bodies have, which is essentially, a lack of independence and lack of impartiality in terms of assessing that. So if you're going to pick one person from the judiciary, pick one person from academia, okay, that has an understanding of these sociological issues and has expertise in those fields. Also pick somebody that is in touch with the community. And of course, subject to the security clearances, et cetera, that they have to go through. But I think it's important that you turn your mind to that, whether it's by codifying it or by at least providing a strong policy directive.
Perfect.
Thank you, Ms. DeBruzen. In order for us to have sufficient time to consider the subcommittee's report, but Mr. Udurga, I know, wants to ask a question or two, so if you can do it in 2 minutes, that would be helpful.
Great. Thank you. Mr. Bouchard, I believe in your testimony you indicated that Canadian security agencies, which includes the Canadian Border Agency, shouldn't accept intelligent information regarding an individual if it contravenes the Canadian Charter of Rights. So do you believe this would require Canada to renegotiate information sharing treaties? Because this has to be done on a global level. Because if we're not going to accept information, there's going to be consequences. And I believe, do you believe that it should be? Do you believe that's the case?
Yes, but we mentioned in our presentation the obligation in Canada because that's what Canada can act on, but obviously it has to be reciprocal. What we're objecting to is what was revealed by Snowden and others, the fact that you can obtain from a foreign agency information by spying on Canadian, which the Canadian agency itself could not have done legally in Canadian laws. In other words, is the fact that by working together, agencies can circumvent national laws, of different countries. So ideally, of course, especially with considering in the close alliance of the Five Eyes, okay, there should be an agreement to the effect that they won't circumvent their national laws by having an agency of another country do what they cannot do with respect to their own citizens.
Thank you. Do you have time for one more question, or I'm done?
You got 14 seconds.
Well, I'm done. Thank you.
Thank you. On behalf of the committee, I wanted to thank Mr. Mirza and Mr. Barrett and Mr. Bouchard for their contributions to the deliberations. Time is the enemy at all of these committee meetings, but your thoughtfulness and your contributions are very much appreciated by the committee. With that, we'll adjourn, ask the room to clear so that we can consider the report. Are we adjourned or we suspend? We are suspended. We didn't adjourn. While we consider the subcommittee's report. So appreciate any cooperation for those who are not supposed to be here. Please leave the room. So thank you very much.
Thank you.